y'all, welcome back to the channel, Celebrity Scandalous. I'm waiting for my 1,000,000 subscribers to come and join the chat, but let's get started. So can y'all let me know if you can hear me? We are going to go over, and I know everybody else is doing it, but I'm doing it now, okay? We are about to go over the order signed by the judge, and it is bad news for Jay-Z. I mean, in the last couple of weeks, Alex Sparrow has been shooting off, coming forward, talking about he wants this case dismissed and talking pretty reckless about the victim, because Jay-Z's been added to this case, Jay-Z, Sean Carter. And so, I mean, I just, based on what we saw with that, which you can't really judge a case based on what you see in the media. You really, really cannot, because there are just so many things that are happening in the background. But anyway, the judge has made an order, and it is not what many of us thought, that possibly the judge would dismiss the case and remove Jay-Z from the lawsuit. That has not happened. So let's get into it. I'm just going to read, no frills or anything. Just read the judge's order. And yeah, it's not good for Jay-Z. I'm sure he is pissed. Okay, so anyway, let me go here and show the order, and I'll just be reading it. Let's see. So it was signed by Judge Annalisa Torres, and which was actually filed and entered today. And we're going to go back to the beginning. I believe it's about 5 pages. So you can see it's the Jane Doe still. The person still remains anonymous. And it's to Diddy, but let me see. It's Jay-Z named here. There we go. And Sean Carter, which you see all the other Does 1 through 10, and Sean Carter. So let's get into what it says. Hold on 1 second, you guys. I got a cough. All right. So it is so ordered by Annalisa Torres, District Judge. Plaintiff Jane Doe filed this action on October 20th, 2024, alleging violation of the New York City Victims Gender Motivated Violence Protection Act, NYC Administrative Code Section 10, blah, blah, et sec. See General ECF number 1. Some of that stuff, I mean, unless you're actually one of the paralegals or attorneys, I don't think we need to get that specific. So I'll try to skip past that. By order dated November 6, 2024, the court provisionally granted plaintiff's motion to proceed anonymously, explaining that defendants had yet to appear in this matter and that the balance of interest weighing for or against anonymity may shift as her suit continues. So the judge made a provisional order, or granted the motions plaintiff to go forward based on the information given at that time. And also noting that the ability to remain anonymous could later change. On December 8th, 2024, plaintiff amended her complaint to add Sean Carter, known professionally as Jay-Z, as a defendant. See, yada, yada, yada. Plaintiff again sought leave to proceed anonymously, but this time Carter's counsel appeared and moved to deny her motion, or in the alternative, to dismiss her amended complaint pursuant to Federal Rule of Civil Procedure, yada, yada, yada. Carter also moved for an expedited hearing on the issue. The next day, Carter's attorney filed a letter containing a declaration from an associate at his law firm recounting a phone conversation she had with an unnamed woman who claimed that plaintiff's counsel encouraged her to lie about her experience of assault. Carter's lawyer asked the court to consider this additional information in connection with plaintiff's motion to proceed anonymously. Plaintiff's counsel denied Carter's allegation against him. Okay, so we can see that the judge is aware of a back and forth. they wanted to, have an attachment that they had some evidence that these allegations were fake and that people were being advised to file this fictitious thing against Jay-Z. On December 13th, 2024, Carter's attorney filed an additional letter alerting the court to a recently published interview of plaintiff on NBC News. So that is the video that we saw with the Jane Doe, and we saw the shadow of the woman talking about the incident. In the interview, plaintiff, speaking anonymously, explained her allegations against defendants and her reasons for coming forward. Carter's lawyer points to the interview in which plaintiff admitted to inconsistencies in her story as evidence that plaintiff's claims have no factual basis whatsoever. He also argues that plaintiff's counsel violated Federal Rule of Civil Procedure by failing to undertake a reasonable inquiry into the facts before filing the complaint and failing to seek admission pro hoc vis to the court. Carter's attorney requested an expedited briefing schedule for a motion to strike the first amended complaint under Federal Rules of Civil Procedure. So this point is where Alex Spiro was saying that Buzzbee admittedly said that he didn't vet the plaintiff, that another law firm did it. So they're trying to use that in this instance here. The next day, Carter's counsel submitted yet another filing, a motion for an emergency order directing the preservation of evidence and striking the amended complaint under rule whatever. So he's just asking the court to preserve whatever evidence, that they had previously submitted in the case that the opposing counsel wants to withdraw something. They're asking to preserve under that rule. Motion to proceed anonymously. So the judge is now answering to the points of their prior motions. You guys, for some reason, my throat gets hoarse, so let me cough a little bit. Okay, so in deciding whether a plaintiff may proceed anonymously, courts have to balance the plaintiff's interest in anonymity against both the public interest in disclosure and any prejudice to the defendant. So, just weigh the balance of fairness. Sealed plaintiff versus sealed defendant, and then they're citing a case here, sealed plaintiff versus sealed defendant. The Second Circuit has laid out a non-exhaustive list of factors to be considered. So these are the things that they will have to contemplate when deciding whether the person could remain anonymous. Whether the litigation involves matters that are highly sensitive of a personal nature, whether identification poses a risk of retaliatory physical or mental harm to the party seeking to proceed anonymously or even critically to innocent non-parties, whether identification presents other harms and the likely severity of those harms, including whether the injury litigated against would be incurred as a result of the disclosure of the plaintiff's identity. So will something happen to that plaintiff if their identity is exposed? Whether the plaintiff is particularly vulnerable to possible harms of disclosure in light of her age. So, a minor, you have to consider the person's age. Whether the suit is challenging the actions of the government or that of private parties. So government versus private. Those are, the way is different. Whether the defendant is prejudiced by allowing the plaintiff to press her or his, I'm assuming, claims anonymously, whether the nature of that prejudice, if any, differs at any particular stage of the litigation, and whether any prejudice can be mitigated by the district court. Whether the plaintiff's identity has thus far been kept confidential, so has the plaintiff's identity already been disclosed? If so, then it kind of might be a moot point. whether the public's interest in the litigation is furthered by requiring the plaintiff to disclose her identity. And in this case, I don't think it's in the public's interest other than for the salaciousness of the story and because we want to know. It's not like it's some big corporation where we would need to know, yeah. And so it's not like it's a public entity or something in which we personally, individuals, private citizens, would necessarily be impacted. That's how I'm interpreting that. Whether because of the purely legal nature of the issues presented or otherwise, there is an atypical weak public interest. Yeah, so that's what I'm saying. It's a weak public interest in knowing the litigants' identities, other than for gossip and salaciousness, right? Whether there are any alternative mechanisms for protecting the confidentiality of the plaintiff. So they're going through the list of how they determine whether or not the person can remain anonymous. A court is not required to list each of the factors or use any particular formulation as long as it is clear that the court balanced the interests at stake in reaching its conclusion. So they're just, let me see. I think I jumped too far. So they're just reiterating that they've done their due diligence. Here, the weight of the factors tip in favor of allowing plaintiff to remain anonymous, at least for this stage of the litigation. As the judge stated earlier, it could change, but at this point, clearly the judge doesn't see a need for the person to have to disclose their identity. Factors 1, 2, 4, and 7 weigh strongly in favor of anonymity. So if we were to go back, we would look at 1, 2, 4, 7. So 1, whether the litigation involves matters that are highly sensitive of a personal nature, whether identification pose a risk of retaliatory physical or mental harm, the party seeking to proceed anonymously. So remember, Diddy's accusers said that they were scared of retaliation. So 1, 2, I think 4 and 7. For whether the plaintiff is particularly vulnerable. So they're using her age because at the time she said she was 13. And then number 7 would be whether the plaintiff's identity has thus far been kept confidential. So it looks like it has been. So those are the factors that the judge used to make her decision at this point. Oh, I got a cough again, y'all. I'm sorry. 1 second. Cough drops, because these things get long and your throat gets dry. So we see the factors that the judge referenced earlier into how she made her decisions. In her amended complaint, plaintiff alleges that defendants drugged and raped her when she was only 13. Amended complaint. So they're saying amended complaint, paragraphs 49 through 60. Courts in this district have recognized that allegations concerning assault are highly sensitive and of an extremely personal nature. And then they're citing prior cases, Doe v. Skyline, and they're giving examples as to the prior case law and or in some instances it would be where there has been a precedent set. So that's what they're referring to here. Plaintiff is particularly vulnerable to the possible harms of disclosure. It said seal plaintiff, and so they're still citing the prior cases. According to her amended complaint, she continues to express depression, post-traumatic stress disorder, and a seizure disorder associated with the stress of her assault. And they're saying amended complaint again, and they tell you to go look at paragraph 61. And then they're also giving you case law, see also blah, blah, blah. Denying disclosure in part because of the risk it posed to plaintiff's already fragile mental state. So the judge is in support of allowing the anonymity because of the things that she's outlined, the depression, post-traumatic stress, and the seizure disorder. So the judge is being sensitive to that. Moreover, plaintiff's counsel asserts that many of his other clients who have filed similar lawsuits against Sean Combs claim to have been threatened by Combs for their decision to speak out. So again, we go back to the whole, I think it was number 4, we go back to whether plaintiff is particularly vulnerable to possible harms of disclosure. Okay, no, that's not it. One to was whether the identification retaliatory. Okay, so I would say it's number 2, whether identification poses a risk of retaliatory physical or mental harm to the party seeking to proceed anonymously. So I guess I can't be jumping back and forth because I'll get lost. So it's saying that other people that have filed cases against Sean Combs, Diddy, claimed they to have been threatened by Mr. Combs for their decision to speak out. And finally, although plaintiff sat for an interview with NBC News concerning their case, NBC allowed her to conduct the interview anonymously. Now, excuse me, that is kind of weird to me because you lose your anonymity because somebody whoever filmed it and whoever did the interview, if they were able to see you, they could disclose your identity. So you're kind of being anonymous at your convenience. If you want full anonymity, then I don't think you should be doing interviews, but I ain't the judge. So granted, several factors weigh against allowing plaintiff to proceed anonymously. Plaintiff is challenging the actions of private parties, not the government. So remember the earlier reference when they were talking about referencing private parties versus the government. So it's not going against a government entity. So, and given the media attention surrounding this case, the public has a substantial interest in this litigation, separate and apart from its general interest in an accused being able to publicly confront an accuser. And then Doe versus Combs. That sounds like another Sean. I'm gonna look that up because I don't know Doe versus Combs, so it may be another case. Alternative mechanisms may exist to protect confidentiality, namely the redaction and sealing of documents. See the prior case. Most importantly, plaintiffs' continued anonymity may cause prejudice to defendants, making it more difficult for them to collect the facts necessary to mount a defense and, as appropriate, challenge plaintiffs' credibility. Now, for me, that was the case that I thought would weigh more heavily, that a person maintaining their anonymity may make it unfair or unbalanced for the defense to have to prepare a proper defense. Again, independent of who the defendants are. We kind of look at it just more from a legal standpoint, take your emotions out. But to me, it just kind of made it a little bit more difficult. And you don't want the defendant to be able to call a mistrial or say that there was anything done inappropriately. So that was what I was thinking initially as to why. And some judges in some of the other cases, judges have decided to make the person file their case and identify themselves, that they could no longer be Jane Doe's or John Doe's. So I just thought this here that it might be prejudicial against the defendants. Identifying the most significant form of prejudice to defendants as the discovery disadvantage that plaintiff's anonymity would present. Yeah, I mean, it's hard to defend yourself against somebody you don't know, you can't prove. I mean, it could be somebody making allegations that you clearly know is lying, but if you don't have all of your evidence to prove that, it seems like it's kind of difficult. The court does not take such prejudice lightly. Okay, so the court is aware that there is an element of prejudice against the defendants allowing the anonymity of this Jane Doe. So they acknowledge it, and they said that the court does not take such prejudice lightly. So the judge is keeping it in mind. She's also said that at some point that could change. So we get that the court is sensitive to all of this, and they should be. That's their job. They're judges. I'm gonna cough again. Sorry, you guys. I'm gonna have to get cough drops. So, nevertheless, at this exceedingly early stage in the case, and I agree with this. So basically, the judge is saying, given all of the details, given light of all of this, and we understand that there's probably a little bit of prejudicial, what's the right word? Unfavor against the defendant at this stage, early in this case. They're going to allow it. The factors counseling against disclosure outweigh that counsel in favor. And then they're citing the other case, requiring plaintiff to identify herself as the case approached trial. So they're giving you a case, Doe versus Delta Airlines. And in this case, the plaintiff had to identify herself closer to trial, which, again, if the person is going to have to identify themselves, why do it later than sooner? But, that's a legal strategy and the judge's decision. Accordingly, plaintiff's motion to proceed anonymously, there we go, is granted. So one thing that we see here, so remember, Alex Spiro wanted Jay-Z's name removed and he wanted it dismissed. He got neither. And if it wasn't dismissed, he wanted the judge to force this person to name themselves, to be named. And all three have been denied. So that's huge. That is huge. I remember when I was, in litigation, the attorneys are supposed to know the judges, right? You know, because it's a very tight-knit community. You know the judges because the judges are seated for years in the same court, and they do the same law. And over years, the same attorneys appear before the same judges. So Alex Spiro should have some knowledge of how this judge rules, their demeanor, what they like and what they don't like. It's like any other industry. You get to know the judges that you're going to appear before. So it looks to me like he's already angered the judge. And I know in the when we look at it from the media standpoint, Alex Spiro was coming out shooting this, and he kept filing things. And oftentimes when you're filing documents, because it's like every other day he would do an amended something, you don't want to piss the judge off. You just don't want to do that. You want to be in the judge's favor. I don't care what people say that the law is supposed to be fair. It's not. Sometimes, they're not supposed to be egregious in their rulings. Like, I'm just going to rule against you because I don't like you. They're not supposed to do that. However, if there's a slight balance of the scale, and the judge favors one attorney over the other, and it's just a decision that probably can't be challenged, they're always going to go with the one that the counsel that they are more favorable to, the one who didn't piss them off or cause problems. And unfortunately, it trickles back down to the defendant or the plaintiff, right? So if your attorney is upped up and the judge has an issue and they do things wrong and they screw it up, you are going to suffer as the client. So plaintiff is advised that because the balance of these factors will certainly shift. So perfect. See, they're already letting us know it is not this order. I won't say it's a temporary order because it's been granted. But what the judge is letting us know is that it can shift, and more probably it's going to shift, especially if and when the parties engage in discovery in earnest. The court intends to revisit this decision at a future date. So as I've been talking about this case previously, I was asking, and I said that during the discovery phase, at some point, whether it's in deposition, whether it's in with the interrogatories or something, I feel like it's kind of hard to have anonymity. I have never been in a case where a person has had and because the law that I did mostly was like contract corporate, so I've never seen, you know, I've assisted in trial preps, but I've never had a case that I worked on where a person was seeking anonymity. So I don't know to the degree as to how it unfolds, but just knowing enough about law and legal strategies that at some point it's almost difficult for opposing counsel not to know your identity, especially for something like this, right? Because usually you're going to probably have some medical records or things that are disclosed, if you know, things that you're going to have to present. I guess the name could be redacted, but it just seems kind of, I don't know, iffy to me. But you know, you learn stuff all the time. So remaining motions. So now the judge is going back, and because there are multiple motions filed, right? It probably wasn't just one, because he was Alex Spiro. I'm talking about Jay-Z's attorney, not I'm talking about Jay-Z's attorney, not Mark Agnifilo. So it says, since Carter's attorney first appeared in this case 17 days ago. Now, see that when the judge gets technical like that, because they could be shady in their comments too, right? I mean, they don't get like crazy with it, but as you can see, there's sarcasm. Since Carter's attorney appeared in this case 17 days ago. I mean, the judge didn't have to say that. And I'm reading this for the first time, okay? So I'm just understanding and getting the judge's tone. The fact that the judge said, since you first appeared in this case 17 days ago, which is like 2 weeks, he has submitted a litany. The word litany is like saying you done inundated me with some bullshit. That's what the judge is saying. I mean, they're saying it with legalese. They're saying it in a way that's, you know, very professional. But he has submitted a litany of letters and motions attempting to impugn the character of plaintiff's lawyer, many of them expounding on the purported urgency of this case. Now, see that right there again. It doesn't sound like the attorney is appreciating the fact that the defendant, that he is trying to take shots at the plaintiff's lawyer. Like, it's like, keep the case about the case, but now you're attacking the attorney. And remember, judges were attorneys at one point as well. So, and they know all of the games that attorneys play, attorneys play. And so she's saying, you're coming for the character of this lawyer. Obviously, she's already correcting you before you go further. I don't like it. And she's saying them expounding the purported urgency of this case. So she's like, pump your brakes, baby. Like, this case was, you've only been on record for two weeks, 17 days. And now all of a sudden there's a sense of urgency. You want me to do this, jump through hoops? No, that's what she's saying. Describing plaintiff's counsel as self-promoting and accusing him of extortion at number 41. And she's referencing a place in the document, requesting to be heard on an expedited basis. Notice how she's calling stuff out, because she don't like it. When they're putting it in the quotes and stuff, they're letting you know. You have to read the tone of the attorney and of the judge. She's really telling you, self-promoting, and you using this language, and I don't like it. And she's saying, requesting to be heard on an expedited basis and accusing plaintiff's counsel of exploiting the legal process to generate media attention. At one, asserting that plaintiff's counsel seek only to benefit himself. And so the references are pointing back to places in the document or the filing where they've said certain things, requesting the shortening of a deadline from 21 days to 1 day. Some stuff is just ridiculous, because there is, I haven't worked on any cases in some years, so I forget some of the legal terms, but everything is done on a timeline. You have court filing dates, you have dates to respond. And so for an attorney to ask for something to be expedited, to move from the regular course of something that's allowed 21 days, because within those days there are multiple things that may be required to happen to day one, probably is unreasonable. And the judge is like saying, what? Like, if your client is not behind bars, there's no like life or death issue here. So for you to ask for something to be shortened to 1 day or something, because and there's so many things that have to be taken into account, so many variables that go into these timelines, and filing dates, return dates, court service, and just a multitude of things. So describing plaintiff's counsel as willing to blatantly, okay, so let me go back. Describing the plaintiff's counsel as willing to blatantly violate the core ethical obligations of all attorneys, and requesting a hearing on a motion the following day. So the judge is like, I'm not even entertaining you. That first paragraph says a lot, and I'm interested. I would love to be in that law firm after they read this, because I know that's like a, whenever your side, when you're working, when you're in a team, you got your lawyers, the paralegals, the secretary, you got all of us working as a group. And when we get stuff back like this, of course, we all read it because we are preparing the documents and we have to help the attorneys respond. It's like, it's kind of egg on the face of the, we if you're part of the legal squad, you'd be like, that's what, because attorneys can be arrogant, but it's also, it impacts the team, because it's like, oh snap, this wasn't good. And then everybody is upset, right? So Carter's lawyers' relentless filing of combative motions. She's just saying, Carter's lawyers' relentless filing of combative motions containing inflammatory language and ad hominem attacks is inappropriate, a waste of judicial resources, and a tactic unlikely to benefit his client. What did I tell you? The court will not fast track the judicial process merely because counsel demands it. She has told him to pump your brakes. She is saying those attacks are inappropriate, wasting judicial resources, asking us to escalate something for what? Like, it's not like a person is on life support and something is going to happen within 48 hours that we have to have a knee-jerk reaction to. No, stop it. And the court, she's telling you right here, is unlikely to benefit Jay-Z. That's bad. That's already, if we were in the law firm, if we were working on this, the judge has a sour taste in her mouth against Jay-Z's attorney. You never want to do that. You don't want to piss the judge off. And it looks like from this, he's pissed the judge off. That's not good. Moreover, I know he's trying to be aggressive and assertive, but do it in a way. Let me tell you something. So I was a litigation secretary, but I also sued a big organization. And because I was a secretary, I would tend to, in my workplace, after I, worked in the law firm and stuff, then I did some other work. I started moving into tech, cyber, and my emails, generally, my writing was always pristine because of my background. And so when people would say stuff, my managers, I was younger, flippant, whatever, I would respond to, workplace emails with legalese almost. And my attorney one time had to tell me, kick their ass professionally, right? So she was telling me, you watch how you talk to your managers, peers, anything, because if you're too assertive or aggressive, you're gonna lose. You do it in a professional tone. So with this attorney, just the way he's hammering and coming, he's making the judge not like him. And they're human. It starts to become personal. It shouldn't, but it does. Moreover, although Carter's attorneys let me slow down. Moreover, although Carter's attorney assails plaintiff's lawyers as having a chronic inability to follow the rules, before I even go any further, I bet you she's going to say, you the one who can't follow rules. At number 3, Carter's counsel has failed to abide by this court's clear rules. So she said, you pointing fingers, but they need to be pointing back at you. Under the court's individual practices in civil cases, and with limited exceptions, a pre-motion letter is required prior to filing of any motion. So you didn't even do what you were supposed to do as you're posturing and talking all this ish. Although Carter's attorney stated that he intended to file immediately a motion to strike the first amended complaint under that rule, he did not give plaintiff the requisite 5 business days to respond. So he must have filed something, and you're supposed, that's what I was saying before, when you try to change these timelines from 21 days to 1, there are different things that happen within those times. 21 days, 2 days to respond, this date, blah, blah, blah. So she's saying you didn't allow counsel to respond. See individual practices. Wait for the court to set a motion schedule or state whether any exception to the court's individual practices applied. This is unacceptable. Y'all, I got a cough in. I'm sorry. So she's basically saying you're making up stuff yourself. You're not following the rules of court. You're not. Counsel is hereby advised that any further motions filed in violation of the court's individual practices may be denied on that ground alone. So different courts, districts, counties have different filing rules, different timelines, different requirements to file certain documents. And so she's saying, you need to follow the rules. I'm going to say local rules, but individual practices to that court, you need to follow those rules for filings. Lastly, although Carter's attorney is entitled to file a Rule 11 motion without first seeking leave of court, see individual practices, excuse me, the court discourages this approach. Now, the judge is already letting you know, don't effing do it, okay? She's saying when the judge discourages you from doing something, you probably shouldn't do it. You can, because she's saying they can. Don't do it. If he still intends to serve plaintiff with a motion for sanctions, the court denies his request to shorten the safe harbor provision contained within that rule. And then she's saying, see, so here we have she's citing things, notes at the, that are in earlier in the pleading. It's probably somewhere up in there. I don't recall seeing it. Carter's motion to strike the amended complaint under Rule 12F is denied. By January 10, 1025, plaintiff shall file her response to Carter's motion for an order directing the preservation of evidence. By January 17, 2025, Carter shall file his reply, if any. The clerk of the court is respectfully directed to terminate the motions 32, 37, 44. So, Annalise Torres has pretty much shot Jay-Z's team down, his attorney, Alex Spiro, and pretty much told him they're going to have to follow the rules of the court. They're not going to get to modify timelines just because they're saying that it's something that needs to be expedited. The judge doesn't think so. And I think the biggest blow that we see here today is the fact that there's no dismissal. Jay-Z hasn't been removed from the case. And the Jane Doe has not been ordered to name herself. So, bad news for Jay-Z. This is not looking good. Yeah. So let me see if anybody said anything. So I'm really just going to, even if confidential okay, so Brooklyn says, even confidential informers, even though they working with the prosecution, you have a right to face your accusers, whether it's a victim or witness, or if they don't face the stand, their name. I agree with you, Brooklyn. It's a constitutional right. You're supposed to be able to face your accusers. However, And the courts can allow a person to remain anonymous. Uh, so I think the judge has to really balance whether or not they are um, making it difficult for the defendant to defend themselves and make a judgment based on that. But just based on what you said and what we've read, it looks like at some point the person through discovery would probably be asked to reveal their identity or come forward, or to some, and maybe it would be in a sealed manner where only the attorneys would know, and they would be able to protect the person's identity from the public, because there's such a high public interest in this case. But yeah, I totally agree with you that I'm going to say probably over 80% of the cases, because when I was researching, because like I said, I never worked on a case where anybody had to remain a doe throughout the case. Generally, when we did the does 1 through whatever, it was before we were, the Jane Does are, generally it's because you don't really know who the people are, and it's just Doe, Jane Doe, until we get the real names. So I really have not had the instance of knowing how it works. If a person wants to remain a doe and an unnamed person in a complaint like this. So very interesting. I'm going to say it's bad news for Jay-Z. Anytime the judge doesn't rule in your favor, it's bad news for the client as well as the legal defense team. And yeah, and more than that, I think and it's not necessarily a win forever, like, because this woman still may have to disclose her identity. But I think overarching is the fact that the judge has had a hard hand in saying that Alex Spiro's his actions, his demeanor is not going to be tolerated, right? And the judge is telling him, you need to simmer down, you need to follow the rules, and she doesn't like his tactics. So all of this calling Buzzbee out and trying to defame him, it's not boding well with the judge. So that's my takeaway. It looks like Spiro may have to change his demeanor in order to get favor again with the judge, because I think this is going to backfire. It's already backfiring. If not, and y'all listen to what I'm saying, if Jay-Z does not even get additional counsel or a new lead attorney. I'm just saying, because when you start getting stuff like this out the gate, where the judge is admonishing the attorney about his behavior to this degree, it's and with people like Jay-Z and Diddy, I don't think he likes this, because this could prejudice the case against him going forward. She just made a comment, it's not going to work well for your client. So if I were Jay-Z, listen, like I said before, I've sued a big company, and I also had a custody case. I got 3 different attorneys, because I knew, like, if something happened that I didn't like, it was like, okay, well, you're not following my strategy, or you screwing up here, I'm gonna have to get this. So lawsuits, it's all about strategy. It's all about who is going before that judge. And I'll tell you, in my own particular case, in my custody case, my case was going, hey, bring the mess TV. The higher ups are turning on him. Yep, I feel like it. It's like, you would think, because they're all of these people are connected. Hey, girl, hey, yes, I went to your page too, and I saw what you posted, and I wasn't like, Country Wayne. Is there a series or something, or is it a video? Because I was like, okay, I didn't understand it, but anyway, you could let me know. But what I was going to say is that even in my case, my custody case, I had like 3 different attorneys. And so I would have to help them. Like, I would find things to help myself, because you should, if you have a case, or, your attorneys have multiple clients, you are just a billable hours. And of course they want to win, but you have to also know certain things as well, or you should be looking up legal facts, looking up just different strategies and presenting them to your attorney. So I was doing pretty good in my custody case, but one thing that really helped is that one of the parents at my daughter's school, the mother, she lost custody of her son, or she didn't get the custody that she wanted. And so she told me, because we had the same judge. So she gave me the attorney that her husband used. And I did the substitution of attorney. I got a new attorney. And when I tell you, that attorney made a huge difference, because he had appeared before this judge so many times. They had a rapport. He knew what to do and how to file things to, butter her up. And everything worked in my favor. But of course it was God. But I'm just saying. So, okay, it says, I know he has a series of skits, but I didn't know what it was referencing, because there was no video link or anything. So I did see it though. So I did come to your page. Again, anybody that's here, go and subscribe to Bring the Mess TV. She has a YouTube channel as well. So yes, girl, this is getting hot. Okay. I really did think that, with the way Spiro was coming and filing these documents and pointing the inconsistencies, because you have to know the rules of the court. Like, we're looking at it on the outside and we're seeing how they're filing things. And, you have to understand the technicalities of what they're filing, the technicalities of the documents, the case law that they're citing, and all of those things. And just on the outside and not really being part of the legal team and knowing their strategy, it sounded like Alex Spiro was coming two-fisted. Hey, I need this dismissed because of the inconsistencies, citing the, case law and all of this stuff. Based on this, it should be dismissed. And it sounded good. However, the judge is coming forward and saying, no, hold up. We're going to let this ride, and you're not going to force me to make this woman name herself yet. And at this point, you've not provided enough evidence to show that this case should literally be dismissed or Jay-Z removed from the case. I mean, that's what we're seeing. Judge Torres is establishing that she has 100% control of her court, and all parties must abide by the... Exactly. Totally agree. Spiro just can't break the rules. Exactly. That's what I was saying. Wait, so your top 20 Louisiana law, can I follow you somewhere? Because I used to be a litigation secretary in California. So, but it sounds like you are in law currently. Can I reach out to you so we can, because you would probably know more current things than me, because I'm cyber now. But let me know. And thank you for joining today. And I hope you are subscribed to the channel. I've been looking for somebody that can provide some, because I have theories and I have, but I am not an attorney. I supported attorneys and did the work, but I also like to have somebody who can give me legal strategies and explain some of the things that I don't know. But thank you for your comment. Yeah, y'all, this is getting heated. I know Jay-Z with Alex Spiro, because remember, Alex Spiro represented Elon Musk. He represented Eric Adams, the mayor of New York. So he's connected to some powerful people as well. And Trump has already said that he's considering a pardon for Mayor Eric Adams. So, if it sounds like Spiro, because of their little, how this whole fraternity works, that he just assumed that he was going to come in and get his way, or at least to some degree. It doesn't look like she's ruled anything in his favor. None of this is in his favor at this point. So I would love to see what Jay-Z, how he feels about this. Because you have to think, Spiro, when I looked up his rates, we're looking at anywhere from probably about, it says his rates are about $2,000 an hour, but given the fact that this is such a high profile case and what's at stake here, I'm going to say his rates are probably closer to like 4 to 5,000. We're going to say we're going to take that 25 and, not necessarily double it, but totally, because you got to think of the teams that are involved in this kind of litigation. Huge. And you're talking about Jay-Z, and then you got all of these companies that are associated with Jay-Z, all of the other things that are surrounded. Like, we're looking at this from the perspective of it's Jay-Z being included in this great lawsuit. However, Jay-Z's name and brand is affiliated and tied to billion-dollar companies. So if they're taking losses like this, you can best believe that the partners at his law firm, that the people associated to this case that are not named, but the Does 1 through whatever that have an association that are connected, they are pissed. This was a loss today. This was a loss. And we're not paying thousands of dollars an hour for us to get an L. No, absolutely not. In cases, I've never worked on a case like this, like a criminal case of assault or anything. But when you have corporations and they're paying, like, these cases can go up into the millions. And we're talking about Jay-Z because he is a billionaire and his affiliations and associations. Do you know everybody gets in trouble? We want to make sure the docs are right, court filings are correct, catch anything. Everybody is going to catch hell for this. Let's watch and see. And let's see if, hold on, y'all. I'm really curious to see if we're going to see some new names or another attorney being part of this Sparrow, like, going to be added on. I think Sparrow is lead counsel now for Jay-Z, but let's see in the next couple of filings or the next what's going to happen. I'm not going to say that they're going to substitute out the law firm, but let's see if there's somebody else or we see somebody else in the forefront of this case with Jay-Z. I'm betting. I could be wrong because I've been wrong a lot about this case as of late. But anyway, you guys, thank you for joining me. Please hit that like button. I forgot to say that. Please hit that like button. Go check out Bring the Mess TV. Girl, get us some content so we can come and support you. And happy holidays. And I will see you guys later. Thanks again. Bye.